just seek to share my screen. Okay, so you can see my slides. You can see and hear me. Okay.
Yes, perfectly well.
Apologies for that disruption. Okay, so welcome everyone, and thank you so much again to Dr. Demetrius Perishu for inviting me to today's session, and also, well done for putting together this session generally, which always looks very exciting. I'm mindful that I'm mostly talking to an audience who I assume is based in Europe, maybe some other colleagues from elsewhere, but given that European assumption, there's probably a few things that I'll need to unpack as I move through this particular presentation. But what I'll do is basically give you a factual scenario to explain the relevance of the topic today and why it might be important. You may have become aware of something called The Voice, which was a recent referendum question that was put to the Australian people to determine whether or not Aboriginal people would make their way into the Australian Constitution, and also whether an advisory body would be set up that would allow Aboriginal people to make representations to Parliament on issues that are of concern to them. So in some ways, that referendum becomes the context in which we might delve into a discussion today about the nature of Aboriginality and how the Australian law, particularly the Australian Constitution, deals with that particular question. So we might ask ourselves, again, as a European audience, why does this matter? What is the relevance of an Australian constitutional question about Aboriginality? What is the relevance of that to me sitting in Europe or elsewhere in the world? And what I would say is that it really gets down to the rule of law. And by what I mean by that is to say that although some European scholars and citizens might struggle to understand the nature of the Aboriginal issues that exist in a country like Australia, because of course Europe has its own history and its own contestations around borders and culture and language and all of those things. And so occasionally when I've spoken to European scholars, particularly when they've visited Australia, they find it difficult to understand what's the big deal. Why are you continuing to talk about these issues? But the reason I think it's important is because if we ask students what the nature of law is, we usually have to come up with some narrative about the difference between a law on the one hand and what might be a rule or a guideline on the other. And usually we end up referring to the Constitution, perhaps the will of the people, through elections, as the source of authority to create law. And when we look to the Australian Constitution, what we find is that it is essentially built upon a series of legal fictions. And so one of those important legal fictions is that of terra nullius. Some of you may be familiar with the Roman law concept of res nullius. Really, terra nullius is to say that there was no one living here in 1788. And so because there was no one living here, there was no need to declare war or to otherwise go through any other mechanisms or processes from a legal point of view in order to establish a colony, and indeed in order to establish a nation down the track and an accompanying constitution. But of course, that wasn't true. In 1788, there were many people living here on this continent, and they had their own developed customs and cultures and law and language. And indeed, there were at least 500 language groups across the continent. And so what I think that Aboriginal issues do in Australia is they place a mirror up to the nation and ask ourselves whether or not the nation and the Constitution are reflective of of the reality. And I think the short answer in terms of where the Australian Constitution is now is that no, the Australian Constitution does not necessarily reflect the reality of the history of this country, and that therefore has an impact upon the nature of law, the legitimacy of that law, and how the law might operate both now and in the future. So I just wanted to give you a little bit of Noongar language. This is the Aboriginal language of the country of the Aboriginal nation where I presently live. So I'm in Perth, Western Australia, but Aboriginal people call this part of the land Noongar country. And in particular, the relevant tribe of where Perth is currently situated is that of Whadjuk. So this is Noongar language. Nala Kadich Noongar Mort, Kan Kadich Nijabuja, Nan Kadich Noongar Kabali Burn Kuriye. And what that is saying is, and it's often said in many public forums in Australia now, it's an acknowledgement of country. So this is simply in Noongar language, me saying that I acknowledge the Noongar people of this country, and particularly the elders past, present, and emerging. The other thing that you'll notice on this slide is what we refer to as the Noongar seasons. So in Perth, or in Noongar, it's called Borlu, where I'm currently delivering this presentation. Unlike much of Europe, where we might speak of 4 seasons, these are the 6 seasons that operate within Noongar country, and we're currently in the season of Camberang, and tomorrow we'll move into the season of Barak. And for many people in Australia, they don't necessarily know or understand the Noongar seasons or the Indigenous seasons of the place where they live. But once they come to understand it, they realise that the weather pattern is indeed very different to what it might be in Europe. And that's, of course, where we have imported our seasons from. And so many people still conceptualise seasons in Australia through the European lens. And that's just one of many examples I could give of the process of colonisation that has taken place in this country, and the effect that that has on the way in which we think and the way in which we act. So what am I going to do today? I want to just firstly outline section 51(19) of the Australian Constitution, and in particular a word in that section which is alien. Now, most of us think of the word alien in the context of extraterrestrial life, but of course the Australian Constitution was written in the late 1800s, and then came into being in the very early 1900s. And so alien in this context simply means from somewhere else. And given the geopolitical world, the tension in relation to immigration, for example, many of the cultural and religious tensions that presently exist, this question of defining other, and then in juxtaposition, defining who is on the inner circle or who is a citizen of a country, is becoming increasingly important, not just in Australia, but indeed around the world. So in my capacity as barrister, I was involved in a matter called Helmbright, and I'll go through the facts of that case. I'll talk about the nature of the intervention, and it was an intervention because I was acting for a third party. So you have you might have a plaintiff and a defendant, but then in this instance you have a third party that comes along that will be affected by the decision, and they can seek intervention into the matter. And a little bit like you may be familiar with the notion of amicus curiae, or friend of the court. That's certainly common in common law countries, but intervention is something different to amicus, but allows a third party to actually make submissions in relation to the case. The judge that was hearing Helmbright was Judge Mortimer, and she outlined 5 critical legal issues that arose in the matter. And so I'll traverse those issues. I'll then talk about what's referred to as the tripartite test. And then I'm going to make some observations about the concept of sovereignty, the concept of belonging, so a few more things about the voice, and then hopefully we can open it up for Q&A after that. Now, feel free if you want to, if you've got any questions along the way, to write in the chat box or otherwise, and I'll do my best if I can actually see those questions. But this is what Section 51 does, and just without going through all of the details of the Australian Constitution, the Australian Constitution is set up not that dissimilar to the United States, in the sense that it's a federation. What that means is that there's a Commonwealth or federal government, and then we have a variety of state governments. So six state governments in Australia and 2 territories. And what Section 51 does, and I know you'll be familiar with this from your own European environment and legal landscape, Section 51 gives the Commonwealth a number of powers. So there are 40-odd subsections of Section 51, and it gives the Commonwealth powers in relation to things like creating currency, telecommunications, external affairs power, which allows the Australian government to enter into treaties or otherwise, and then to essentially enact legislation along those lines. But we also have Section 19 or subsection 19 of Section 51. And so the chapeau, or the opening paragraph of Section 51, says the Parliament, and that's really the Commonwealth Parliament, shall, subject to this Constitution, have powers to make laws for the peace, order, and good government of the Commonwealth with respect to. And then naturalisation and aliens is, as I said, Section 51, subsection 19. So what that means, of course, in practice, is that the Australian government can make decisions about who is a citizen of this country, who can be subject to an effective visa, so they might be able to stay in Australia even without citizenship or otherwise. Importantly, though, and this is, of course, one of the other aspects, not just of federation in terms of dividing power between a Commonwealth and the state, but of course we also have the separation of powers between the legislative, the judicial, and the executive. And that becomes particularly important here in the context of Section 51(19), because there's only one body that can interpret the Australian Constitution, and that's the High Court of Australia. And so that becomes particularly important, because what that means is that when we are trying to decipher the meaning of Section 51(19), we have to rely upon the interpretation that the High Court places on the word alien, as opposed to what the government might want alien to mean. So there's an important nuance here between alienage on the one hand and citizenship on the other. So the Australian government can make decisions about who is a citizen, but they cannot make decisions about who is an alien. And the reason that is because alien, as I said, is in Section 51(19) of the Constitution, and it's for the High Court to interpret the meaning of that word, not for the Commonwealth government to determine. So Helmbright, and I've got the full list, the full name of the cases up on the screen there, and you can also find the links on my profile where you can actually download the PDFs. But the main one that we're concerned with is number 2. So number 1 related to the intervention, number 2 is really the substantive matter, and then number 3 related to costs. So I'll say a few words about all of these 3 matters, but the focus is going to be on number 2. So Helmbright relied upon another decision by the name of Love and Toms. And Love and Toms was an important High Court decision in 2020. Now, what's happening here is that you might have a person that has Australian Aboriginal heritage, but they are not actually born in Australia. So if you imagine a person that might have Aboriginal heritage from Australia, but they're born in New Zealand, for instance. They then come to Australia and let's say they commit a crime and they end up in prison for 12 months or more. Once that occurs, the immigration minister then has the power to extradite that person once they come out of detention or out of prison back to the country in which they came using an immigration power. But if you imagine a situation where the person that came from New Zealand was an Australian Aboriginal person or had Australian Aboriginal heritage, they committed the crime, they then are being deported to another country on the basis of a particular sections of the Migration Act. And they put up their hand and they say, excuse me, I cannot be deported from Australia because I am actually an Australian Aboriginal person, or at least I have Australian Aboriginal heritage. And so therefore I cannot be an alien of this country because this country, I am of this country. My heritage goes back at least 65,000 years. So I can't possibly be an alien of this particular land. And this is the context in which this decision came into the High Court, where people are essentially non-citizens of Australia, but they might have that Aboriginal heritage. And the real question is whether or not they are an alien or whether they can be constituted as an alien, because if not, then what the High Court would say is that the Commonwealth Government does not have the power to deport that person on the basis of Section 5119. So Helmbright was a follow-on case from Love and Tom's, and we had a situation not that dissimilar to the example I just gave, where Helmbright was born in New Zealand in 1983, and he was a citizen of that country. His Aboriginal heritage was from Tasmania. So for anyone that is familiar with Australia, you have the big continent, and then you have a little island underneath. And the little island is one of the 6 states, being that of Tasmania, also known as Lutruwita. So in 1792, not long after James Cook landed on the shores of Botany Bay, which is now Sydney, in 1788, we had an Aboriginal woman by the name of Pulrarina who was part of the Perrabeen clan. And without going through all of the lineage, essentially Helmbright can be traced back from a lineage point of view back to this Aboriginal woman and indeed back to this Aboriginal clan in Tasmania in 1792. For context, during the 1800s, there was quite a significant whale industry and also a seal industry. And so many Aboriginal people ended up getting involved in both whaling and sealing. And that is how they often ended up in New Zealand. And those Aboriginal people would then connect with the Maori people, the Indigenous people of New Zealand, and have children and live lives and all the rest of it. So you can imagine a world even in the 1800s where someone had Aboriginal heritage but ends up being born in New Zealand, albeit it might be that just one side of the family is Australian Aboriginal and the other half might be Maori or some other cultural heritage. Now, the history of Aboriginal people in Australia is one of devastation for the most part, in the sense that there were many massacres throughout the 1800s, but in Tasmania it was particularly harsh. Initially, the history books would say that there were at least 20,000 Aboriginal people living in Tasmania in the early 1800s. But it wasn't long before those 20,000 people were reduced to 11 women and 1 man. And from those 11 women and 1 man, there are today about 25,000 descendants. And as it happens, Helmbright was one of these, is one of these 25,000 defendants. Now, in 2005, Helmbright moved from New Zealand to Western Australia, where I live, and he's lived here ever since. He has been provided with 2 different types of visas since he has been here, because as indicated, he is a New Zealand citizen, so he does require a visa to be here. Now, because he did commit a crime and he ended up in prison for 12 months, when he came out, the relevant immigration minister notified Helmbright that his visa would be cancelled under Section 501 of the Migration Act. And it was at that time that Helmbright started to ask questions about his own Aboriginality, because in prison, but also prior to prison, he was starting to discover a little bit more about his own cultural heritage and his own lineage, and he was trying to find out everything he could about it. So he actually raised this issue with the Department of Immigration back in 2017 to say, well, I'm actually partly Aboriginal, and so it doesn't make sense that I am going to be deported from my own country, even though I'm not a citizen. The immigration minister wasn't particularly enamored with those arguments, and so he continued to cancel Helmbright's visa, and he was then in the process of being, well, not extradited, but essentially thrown out of the country and back to New Zealand, where he came. In Australia, we have a body called the Administrative Appeals Tribunal, which is not actually part of the court system, but it's a review, it's a quasi-court in a way, although it's part of the executive government. And the role of the Administrative Appeals Tribunal is to review government decisions to make sure that those decisions have been made in an appropriate way. And so Helmbright took this decision of the minister to the Australian Administrative Appeals Tribunal in 2019. And it was in that instance that decisions were made about him being deported back to New Zealand. There's a few things that happened, but basically by the time we get to 2020, the minister reinforced that Helmbright would be cancelled, visa would be cancelled. But interestingly enough, it was at the same time as this, within a week, in fact, that the minister had affirmed this cancellation, that the previous case that I mentioned, Love and Tom's, was handed down in the High Court. So I think the minister notified Helmbright on the 5th of February 2020 that his visa would be cancelled. And then 6 days later, on the 11th of February, the High Court handed down its Love and Tom's decision. And importantly, we have 7 judges on our High Court, and 4 of those 7 judges said that if you are an Aboriginal Australian, you cannot be an alien of this country. The other 3, of course, adopted a different point of view, so it was a 4-3 split, so a close decision. But the majority decision was essentially that someone like Helmbright should stay. Now, of course, you then get into some interesting questions about how to define an Aboriginal person. Because if it's the case that you cannot be an alien if you're an Aboriginal person, then we obviously need to ask some further details about how one defines Aboriginality. So some of these issues will require unpacking. So I'll just give you a moment to read the slide, and then I'll go through a few aspects of this slide, particularly referencing Mabo number 2 and the Tasmanian Dam case. So we don't need to understand every single aspect of the issues that are presented, but it's useful, I think, for you to understand a few things in order to provide some context here. In 1992, the Australian High Court handed down what's probably one of the most important decisions it had ever made to that point, which was the Mabo decision. And what the Mabo decision did is it essentially overthrew the doctrine of terra nullius I referred to at the beginning of today. That is, the High Court looked at all of the factual evidence before it, and it made the decision that the notion of terra nullius was a false legal doctrine that should not have applied to Australia in 1788 or indeed at any time subsequent to that. It found that there was a rich, deep Aboriginal culture in 1788 that was living here, and what that has led to is what we call in Australia native title rights. And so that gives Aboriginal people the opportunity to gain particular rights over land if they can demonstrate that they have maintained a cultural connection to that land over time. And so in making that type of determination, it was also the case in Mabo that the High Court made some comments about how one is to define Aboriginality. But that was a case in 1992. We had an earlier case in 1983 by the name of the Tasmanian Dam case. And the Tasmanian Dam case was really, it was an environmental battle, essentially, that ended up in the High Court about whether or not a big dam should go ahead in a wilderness, in a sort of very much high conservation area in Tasmania. Aboriginal issues also became relevant because there were some Aboriginal artifacts where the dam would have arisen to, or that would have submerged, the dam would have submerged various Aboriginal artifacts. And so it became important in Tasmanian Dam to also make determinations about who is an Aboriginal person. And so without going through all of the history of those cases of Tasmanian Dam and Mabo number 2, what we began to see during the 1980s and the 1990s was some legal definitions emerging about how one actually defines being an Aboriginal person. And so where we have got to in relation to that is what's called a tripartite test. And I'll go into the tripartite test in a little bit more detail in a few moments. But essentially, it's tripartite because there's 3 limbs. And the first limb is descent. So where are your mother and father from, essentially? The second is essentially self-certification. So someone that self-identifies as an Aboriginal person. And then the third limb is community recognition. So that Aboriginal groups recognise that person as being Aboriginal. And those 3 limbs become part of the definition of what it is to be an Aboriginal person. So in Australia, it may be that we have native title groups, or it may be that we have other Aboriginal cultural groups that make determinations about whether or not someone is Aboriginal or not. And in Australia now, we have something emerging, often referred to as an Aboriginality confirmation framework, or words to that effect, which essentially allow Aboriginal people to get certification that they are in fact Aboriginal. And that may become important for a number of reasons, one of which is what I'm describing in relation to Helmbright. It may, for example, provide a defence from being deported from this country if you can make that determination. So the relevant group in Tasmania is called MTWAC, or I've put the Indigenous name there, otherwise referred to as Heart of Country. And that group makes determinations about Tasmanian Aboriginal people and their heritage. It was a group that was founded in 2008. It's got a board of directors, but also what's referred to as a circle of elders. And the board of directors will sometimes consult with the circle of elders from time to time to make determinations, as I say, about who is Aboriginal and who is not. So in my capacity as a barrister, I was acting for NTWAC. They were a third party because we had essentially the immigration minister, we had Helmbright, and then we had NTWAC. And the reason that NTWAC had an interest in this matter is because if the court formed the view that Helmbright was not an Aboriginal person, well, because NTWAC had certified Helmbright as Aboriginal, they had formed the view that that they would their whole organisation would essentially be redundant, because if the government wasn't going to listen to their determinations about who was Aboriginal and who wasn't, then that obviously has an existential implications for the organisation. So on that basis, an intervention application was made to the federal court, and that intervention was essentially granted by the court. So we now get to the tripartite test, which I mentioned. And although this test initially found its way into the High Court in the Tasmanian Dam case, which was a case in the 1980s, there were a number of reports, government reports and otherwise, that took place before the Tasmanian Dam case, which essentially talked about these three limbs and how they might apply. And as I've implied, from the 1980s through to the 1990s, there were different views about how the tripartite test should be applied. So the Tasmanian Dam case took what we might refer to as a pan-Aboriginal perspective. So I referred to the fact that within the Australian continent, there are probably at least 500 Aboriginal language groups across the continent. And the Tasmanian Dam case takes what you might call a pan-Aboriginal perspective, which is to say that even though there are 500 subgroups, or maybe more, depending on how you construct these things, there is one concept, which is that of being an Australian Aboriginal. So you can be an Australian Aboriginal, and it's not necessary to determine precisely which subcategory you might fit into. It's just that you are an Australian Aboriginal. So in other words, there's one definition of what it means to be an Aboriginal person. Mabo number 2 is more based upon the local connection that an Aboriginal person might have to a particular geographical area. And so under the Mabo number 2 definition of Aboriginality, one would need to demonstrate that they have some sort of connection to country in order to demonstrate their Aboriginality. And the notion of pan-Aboriginality is really downplayed, or otherwise not particularly important in determining whether someone is Aboriginal or not. And so much of the debate within the case was about this question of what sort of connection an Aboriginal person needs to have to country or to culture in order to demonstrate their Aboriginality. And this is one of the quotes from Justice Mortimer in the Helmbright case, number 2. And she's referring to the NTWAC submissions. And she says, to equate community recognition with continuous connection is to conflate an inquiry concerning citizenship and alienage with an inquiry concerning property rights and native title, and can lead to circularity because being Indigenous is a precondition to holding native title. MTDWC therefore submits that this court can and should find that recognition by a Yorta Yorta society that holds or is entitled to hold native title is not necessary, either by applying Justice Dean's test in the Tasmanian Dam case or by taking a flexible approach to the Mabo number 2 test. So I recognise that that's a complicated few sentences, and there's a number of concepts that we could unpack, including reference to Yorta Yorta society. But we don't really need to get caught up in the details of all of this today. The main point that I'm making here is a question of whether or not an Aboriginal person needs to have direct connection to country, or whether they can be an Aboriginal person without having a connection to a particular geographical area. And of course, much of this depends on our perspectives of whether or not a particular culture is allowed to evolve over time. Because of course, the traditional Aboriginal culture was to be connected to country, because that's where you got your food, that's where you got your language, that's where you got all of your spiritual nourishment, was from the actual land in which you were residing. But of course, we are living in a different era now. And the real question is, can Aboriginal culture evolve such that it doesn't need to have that specific geographical connection, but yet can still maintain some level of cultural integrity? Again, these sorts of issues might be difficult for non-Australians or indeed Europeans to conceptualize because of your own respective histories. But I think that if you thought deeply enough about the issues that we're talking about, there would be some similarities with the sort of issues that might arise in a European context, for example, and the sort of issues that are arising here with Indigenous Australians. I mean, after all, every country has to grapple with the idea of who is a citizen and who is not a citizen of a particular country. Now, one of the points that was made along the way in the Love and Tom's case, well, look, some judges say that every case must have an outcome, but not every case must have a ratio decidendi. In other words, we always need to come up with a resolution to a legal dispute, but it's not always easy or indeed possible to extract the ratio decidendi or the main rationale for that decision within the decision itself. But Love and Tom's made it a little bit easy, because in paragraph 81 of Love and Tom's, one of the majority judges, so one of the 4 majority judges, said that she was authorized to make this comment on behalf of the majority judges. So she essentially outlined what is basically the ratio of the case, which is that Aboriginal Australians, understood according to the tripartite test in Mabo number 2, are not within reach of the aliens' power conferred by section 5119 of the Constitution. So that was a very clear statement, which essentially said that Aboriginal Australians cannot be aliens of this country. But you'll see that in brackets, it refers to understood according to the tripartite test in Mabo number 2. And that was a different test to the one that was applied in the Tasmanian Dam case in 1983. And so that's what the dispute became about in Elmbright, was, well, what does it mean to be an Aboriginal Australian according to the tripartite test in Mabo number 2? Because Mabo number 2 was all about native title. It was about rejecting the terra nullius doctrine that no one was living here in 1788, and accordingly providing rights to Aboriginal people, mostly in relation to land, so that Aboriginal people could either access or have other rights in relation to land that they remained to connect. there is a hierarchy within the court system in Australia. So the High Court of Australia is the highest. But underneath the High Court of Australia, at the Commonwealth level, we have the Federal Court of Australia. And so the Federal Court of Australia has powers to deal with Commonwealth matters arising. And then if it's going to be appealed from the Federal Court, then it will usually go to the full Federal Court, then the High Court. That's at the Commonwealth level. At the state level, it's a different court structure. So we have local courts, district court, Supreme Court. That's the hierarchy. But here we're talking about federal issues. So it's really only the High Court and the Federal Court that are relevant to this particular discussion. And because the Federal Court is below the High Court in hierarchy, the Federal Court has to follow the precedent of the High Court. And so because of paragraph 81 of Love and Toms, which I just rehearsed, that meant that Justice Mortimer in the Helmbright case felt like she was bound to the tripartite test in Mabo number 2, because that was the articulation of the ratio of the majority of the High Court in the Love and Toms matter. Interestingly, though, when we unpack what the Mabo number 2 approach is actually about, Justice Mortimer had a more nuanced perspective of the connection between native title on the one hand and this question of citizenship and alienage on the other. And it really goes back to the quote of Justice Mortimer before, when she's talking about this idea of conflating issues relating to property rights and native title on the one hand with citizenship and alienage on the other hand. Obviously, property rights are a very different thing to citizenship. And what Justice Mortimer is essentially observing is that by the Commonwealth government seeking to apply what is been referred to as the native title approach or the Mabo number 2 approach, the government is confusing property rights with citizenship. And so for that reason, Justice Mortimer wasn't compelled to adopt what has now become the native title approach. And she was much more interested in this pan-Aboriginal concept of how we might think about Aboriginality in a way that does not rely upon reference to native title processes. And so Mortimer goes on to say this in paragraph 148 of her decision. So it becomes a little bit confusing because if you read what she's referring to there, she's essentially outlining what the Mabo number 2 tripartite test is, but you can see that there's not actually 3 limbs. There's really just 2. So what this Mabo number 2 approach does, it collapses limb 2 and 3 into one mutual recognition story. So you still require the first limb, which is biological descent, but self-identification and community recognition become merged into what's referred to as a mutual recognition. And that's important because what it's suggesting is that recognition has to be both ways. The person has to self-identify, but the group also needs to mutually recognize that self-identification. Now, it's not altogether clear what the practical effect of this more nuanced approach with Mabo number 2 might mean in practice. But it just demonstrates, I guess, the blurry and difficult nature of defining a particular people's, a particular culture, and the sensitivities involved with that, because even up until the 1960s in the city that I'm living in now, in Perth, it was illegal for Aboriginal people to speak their language. And as I said, many of the massacres that began in the 1800s or late 1700s continued well into the 1900s. And so there was good reason for people during those periods of time to not identify as an Aboriginal person, because to do so would often mean various types of discrimination or much worse. And so we're now living in an era where we are essentially seeking to reconcile the history with the present and finding legal mechanisms in order to do that. But one of the really interesting comments that that Justice Mortimer made in Helmbright is this. In substance, the difference between the minority and the majority in Love and Tom's was whether this relationship between Indigenous peoples and their land and waters could say anything in legal principle about their relationship with the polity of the Commonwealth of Australia. And that's where it becomes interesting in terms of this pan-Aboriginal concept, because what the majority in Love and Tom's basically said was that by virtue of being Aboriginal, you belong to this country. And so there was a lot of emphasis being placed on this concept of belonging. And it ties also into this question of sovereignty, which really lies at the heart of every legal system, right? You can't really have a legal system without a concept of sovereignty, because it goes back to the question of the rule of law and authority and how we actually make determinations about what is valid and what is not from a legal point of view. And as I said, many Western democracies will use constitutions and the accompanying will of the people in order to create the requisite authority to create law. But if you don't have that chain, and this is often the case when you move into international law, because you don't have an international sovereign that can create international law. So international law becomes much more blurry than the domestic law. When you don't have that chain of authority, it in a sense creates a little bit of an existential crisis for the creation of law and for the creation of legal systems. And that is what Australia has been going through now for some time. So I'll just allow you again just to have a quick read of this passage in paragraph 345. So what I think is happening in the Australian context is that the legal system is beginning to sow the seeds of Aboriginal sovereignty within its judgments. You can see here that Justice Mortimer, being a federal court judge, is unable to take the next step. She's bound by the High Court, which is above her, and she's not able to fully adopt this pan-Aboriginal concept. But you can see that there's a flirtation with this idea that we could create a sense of belonging that's not necessarily dependent on a direct link to a particular geographical area within the continent. Rather, you just become a member of the Aboriginal community in a more general sense, and by virtue of being a member of that Aboriginal community, you are therefore an Australian Aboriginal, and therefore you can never be an alien of this country. You could therefore never be deported as a matter of legal principle. And one of the things that Love and Tom particularly emphasised is this idea of sui generis, or one of a kind. And they say that Aboriginal Australians are indeed one of a kind because of the 65,000-year history within this country. And therefore, it's not to discriminate as such and to treat Aboriginal people differently to non-Aboriginal people by virtue of the Aboriginality. It's more that the question of belonging, cultural belonging, is such that it is one of a kind. Like no one else can make a claim, a 65,000 year historical claim to having a connection to this country other than Aboriginal people. So it's not so much about discriminating on the basis of race, although of course the history makes things very complicated comes to these things, because that is in fact what did happen in history. But in a contemporary society, I guess the High Court has asked questions about whether race is actually even a real thing scientifically, a little bit like gender and sex. We can have the discussion about the science of these things and then the socio-political dimensions as well. And that's something that comes out a lot in the Love and Tom's case, where they're talking about the question of whether or not race is even a scientifically valid concept. And interestingly enough, one of the judges uses the phrase belonger, which is to say that Aboriginal people belong to the political community, and even goes so far as to say that they are essential members of the community which constitutes the body politic of the nation state. Now, as it happened, I should at least let you know what happened in Helmbright, which is that Justice Mortimer indicated that Helmbright did not actually meet the mutual recognition requirements, that is the Mabo number 2 requirements of the tripartite test, because although MTWAC had a circle of elders, which was essentially how traditional authority was to be manifested in that community, there was no factual evidence that was put forward before the court that demonstrated that mutual recognition actually took place by reference to the circle of elders. And so because of the factual matrix that was presented in the case, Justice Mortimer was of the view that the threshold was not met for mutual recognition, and therefore, in this instance, Helmbright was not able to challenge the minister on the basis of his Aboriginality, even though the legal principles were maintained. The factual matrix and the factual threshold was not established in this particular instance, and therefore Helmbright became liable to deportation. Now, as a matter of fact, Helmbright has not actually been deported as far as I know, even though legally speaking, he probably could have been. And that's as much to do with politics as it is to do with the law, which is to say there was a change of government in 2022, and there's been some policy shifts in relation to the way in which the Commonwealth government has sought to deal with these sorts of issues. The final substantive matter that I guess I'll mention is the question of costs, because as a barrister, it's often important when representing clients to think about, well, you might win a case, but if you have to still pay all of the costs in relation to that matter, then it's not much of a win most of the time. And so there was a question within the Helmbright case, because as I indicated, Helmbright did not actually succeed in his case because of the factual deficiencies. And so theoretically, he might have had to pay the legal costs associated with his intervention. But in this particular case, the judge indicated that costs would not need to be paid, particularly by MTWAC, because of the public interest involved in seeking to bring this matter before the courts. And so in some ways that was a win for public interest litigation, because as you know, cost orders can be very crushing on clients, and particularly on relatively small community organisations. And so I'll just let you have a read of that last quote before I say a few words about the voice and then finish off. So effectively, if an intervention occurs in a measured, effective and efficient way, then it's unlikely, according to the federal court, that the organisation will be subject to a cost order or a detrimental cost order against them. I began today by referring to the referendum. Some of you may have heard of it, some of you may not have, but essentially this referendum took place on the 14th of October, so about 6 weeks ago. And it really had two things before it. And so a referendum is required in order to change the Australian Constitution. And it's quite a difficult task in Australia. Only 7 or 8 have got up over at least 40 propositions over the years. And not only do you need a majority of all citizens to vote to change the referendum, but you also need a majority of the 6 states. So you need a majority of at least 4 of the 6 states, as well as a majority of the actual citizens themselves. And history has demonstrated that if you don't have bipartisan support, in other words, in Australia, we generally have the coalition and the Labor government, and without the support of both sides of government, with a referendum, it will generally go down. It will be unsuccessful. And that was the case with the voice. So the voice flowed from a statement called the Uluru Statement from the Heart in 2017. And it's a 1-page statement that you can find on the internet, and it's quite worth reading if you're interested in Aboriginal matters. Basically, an easy to understand 1-page summary of what Aboriginal people were asking for in 2017 in order for them to feel like they're being respected and having a level of self-determination. One of the things that they asked for was a voice, and what that voice meant in practice was essentially, as I indicated previously, an advisory committee role whereby representation would be established that would allow Aboriginal people to make representations to Parliament and to executive government on issues that affect their daily lives. Unfortunately, that particular vote went down 60% to 40%. And so it wasn't particularly close, even though the polling 12 months out from that referendum indicated 60% support during the course of over a 12-month period. That 60% support moved to 40% support. And so we're now in a place in Australia where it's difficult to determine where to from here in relation to what we call reconciliation between Aboriginal people and non-Aboriginal people. And part of that story relates to some of the issues that I've been canvassing today. So what I tried to do, without going into too many details, is just to give you an overview of this question of whether or not an Aboriginal person can be an alien in Australia. That particular legal question flows from section 5119 of the Australian Constitution. We learned that Helmbright was a person living in Western Australia, where I'm presently presenting. He had Tasmanian Aboriginal heritage, but was born in New Zealand. So therefore, he was a New Zealand citizen. He'd come to live in Australia. He'd acquired a visa to do so. But in Australia, if you have a visa and you commit a crime and you end up in prison for 12 months or more, then when you leave prison, you can be deported back to the country in which you came. But the question of whether or not you're an Aboriginal person can now complicate that process, particularly because of the majority decision in Love and Toms. So I talked about the tripartite test, which generally speaking means descent, self-identification, and community recognition. But I also talked about the nuanced approaches between the Tasmanian Dam case, which is a pan-Aboriginal concept, and the Mabo number 2 approach which tends to be more grounded in a geographical area, and for Aboriginal people to demonstrate a connection to that geographical area in order to prove their Aboriginality. But ultimately, these issues are still in play. What I would say is that if you look to the future, that the seeds are now being planted within Australia, particularly within the legal system, to be able to demonstrate Aboriginal sovereignty. Now, Aboriginal sovereignty doesn't mean that Aboriginal people would then overthrow the Australian government. What it means is that you can have coexistence of sovereignty. So you can have the Commonwealth of Australia can exist as a sovereign country and nation, but it can also be the case that Aboriginal people can also have their own sovereignty. And that's how native title essentially works. We have property rights that exist in this country, but native title rights will often sit either alongside or on top of or next to other rights. And so we can start to conceptualize the concept of sovereignty as a coexistence story. And part of that narrative is this idea of belonging. That is to say that Aboriginal people have a sui generis or one-of-a-kind claim in relation to their connection to this particular continent because of the 65,000-year history, which is well documented in courts and in government reports and in many other pieces of literature, historical and otherwise. The Voice has been a recent contemporary experiment that has essentially failed, and it's now left Australia at a crossroads in terms of how it reconciles its history with its present and future. And so perhaps if I'm giving one of these presentations in 10 years, I'll then be able to report more accurately on what the future holds. But at this point, I think it's a pretty dangerous proposition to predict the future, both in Australia and indeed around the world, given the nature of the geopolitical circumstances we live in. So, Dr. Demetrius Parushu, thank you so much for, again, inviting me, and happy to field questions, take comments, and otherwise generate some discussion. Thank you so much.
Thank you very much, dear Dean Cunningham, for this very interesting presentation, which I personally enjoyed very much, and I'm pretty sure that our fellow participants also enjoyed the same way. Dear ladies and gentlemen, I'd rather not be the first one to go with questions, so please feel free to ask Dean Cunningham. Well, in that case, I'd then rather start. And I have to admit, personally, I followed that referendum quite closely. I was particularly intrigued, not only because of my Greek roots and matters of direct democracy, but also generally about the subject. I mean, my personal impression was that it was merely a clash between the major political parties, and you also mentioned that if you want to succeed probably with something, you would need the support of both major political poles. So my personal impression was that well, as soon as the Liberal Party opposed to the whole subject, then popular support would then be obviously reduced, and so we get that a lot also in Europe, of course. That, for instance, back then in the early 2000s, with the idea of creating a constitution for the European Union, several referenda in member states did not succeed due to political reasons, oppositional reasons of well, the major parties between them, So that would be my personal impression. Of course, I'm I'm not Australian. It was just since I followed that properly, that was the impression and the conclusion to which I get. But you mentioned the matter of reconciliation, and you also said that any sort of prediction would be difficult to be done and also dangerous. And you're perfectly right. I'd like to ask you though, you personally, having these elements in mind, would you tend to be more optimistic towards matters of reconciliation and regarding the whole aftermath of the story?
Yeah, so look, I think it's easy to look at some of these issues and to correlate them with identity politics, for example, or think of it through the lens of a culture warfare. For instance, the left versus the right, or however you want to conceptualize these types of struggles. But what I think, an observation from my point of view around the voice, is that it was really about how our democracy functions. And although we can talk about the machinations of bipartisan support or the lack thereof, and you're right, and I'm very honoured, in fact, that you've been engaging with this issue, Demetrios, that you're actually aware of what's going on in the Australian political landscape. I'm flattered by that, because it's, but it's I mean, whether we're talking about Trumpism or whether we're talking about the voice, the dynamics that are playing out are similar, in that we obviously have algorithms that are tabloid newspapers on steroids now, that are ultimately about dividing opinion, dividing perspective, rather than bringing people together. And so, as I say, it doesn't matter really what your views are in relation to, let's call it gay marriage, or the voice, or any of these sorts of issues. I think there are deeper questions to be explored about the way in which our democracy is functioning, and our ability to find common ground in a pluralist society. I think it's possible, but there is political opportunism at play that often allows for political gains to be made by opposing things rather than finding that common ground. And that's certainly what happened in the Australian landscape, where there's no doubt that the current Prime Minister, Anthony Albanese, has been politically damaged by the voice outcome. And equally, it's the case that the opposition leader, Peter Dutton of the Liberal Party, is in a much better place now than he was 6 months ago, by virtue of opposing the voice. So even though these issues have been on the table in Australia for 30 or 40 years, we haven't really made a great lot of progress institutionally, aside from a few hiccups. And Mabo is one example, where, in a sense, the political system was unable to do the heavy lifting. So the High Court did the heavy lifting on behalf of the government back in 1992 by overturning the terra nullius doctrine, which no politician was willing to really do. But the High Court was able to make those changes through a legal frame rather than through a political frame. So it's a long way of answering your question, but what I would say is that there is a role for the law in developing the political landscape, and particularly in the constitutional law domain. This is where the seeds are planted for future political moves. Now, obviously, it will depend on the political landscape as to whether or not those seeds are able to grow. But the seeds of sovereignty for Aboriginal people have been planted in the Australian legal system. And that's one of the key points of my presentation today. Those seeds have been planted. Now, the question of whether those seeds germinate, whether they grow, whether they turn into something else, will largely depend on the political landscape over the next 10 to 15 years. But one thing we know about referendums, because we had a referendum back in 1999, which was our last referendum, to ask the question whether Australia should be a republic. And that the result of that was almost exactly the same as the voice. So that referendum went down. So you don't get these opportunities much. And in Australia, I don't expect there'll be a referendum around Aboriginal people for another 20 years. And so it'll be interesting to see what happens between now and then from a political landscape point of view.
Thank you very much. We have another question here by our dear Miss Aso. She has a question about political rights to indigenous communities also held their own political organs. For example, have they specific guaranteed seats for them? So
the short answer to that question is no. There are no particular political rights. The voice was an attempt to create some level of political representation, but not in the normal sense that we might understand political representation. So they weren't elected positions that were to be established. But the reason why the voice became a focal point for Aboriginal people was that over the last 40 or 50 years, there's been a number of different bodies that have emerged to represent Aboriginal people and allow those people to make representations to Parliament. But what's happened over the last 30 or 40 years is that that every time the government doesn't like what Aboriginal people are saying, then they just shut down those organisations and silence them in that way. So that the idea of the voice was to place it into the Constitution so it could not easily be changed or altered by one government or another. But again, the short answer is no. And although the voice wasn't going to provide the sort of representation that you're speaking of, it would have been a halfway house between that type of representation and where we are now. And the idea with the voice was to create a pathway of truth-telling, which is perceived as being important as part of the reconciliation process. We can think about South Africa, for example, as going through these sort of truth and reconciliation processes as being important. But it was also about creating the possibility of a treaty between Aboriginal people and the Australian government, because I mean that's something that happened in New Zealand in the 1800s, that there was a treaty between the Maori people and the New Zealand government, but there has never been a treaty between the Commonwealth Government of Australia and Aboriginal people. And so that's, if I am to predict the future, that's where things will go eventually. But then those questions about pan-Aboriginality will become particularly important, because if you're going to create a treaty between the Commonwealth Government and Aboriginal people, are you just going to have one treaty, or are you going to have many treaties with many different Aboriginal groups? And that's where things might become quite interesting, and where the topics of today will become even more important, because we will need a system or a way of devising how you define an Aboriginal person, how you define Aboriginal groups, and if there's a treaty between the Commonwealth Government and Aboriginal people, what does that representation and treaty making actually look like in practice?
for sure. Thank you very much. Any further questions, dear ladies and gentlemen? You may also feel free to use your mic if you are not so much into the chat.
While people, just in the event there is one or two more questions, I'll just make or reinforce a comment that I made along the way, which is that although it may appear that I'm talking about a relatively niche issue relating to Australia, I think there's some deeper jurisprudential questions that underpin what I'm saying, which is really about the nature of law and how one validates constitutions and political systems. And I think because of the era that we're living in now, where there is so much, there's so much I call it false division. There's division is valid, but there's a lot of division that is based on misinformation or disinformation, or that's a manifestation of other agendas or interests that are playing out. And I think in that type of world, it becomes more and more important for the institutions, the constitution, the legal system to have a rational validity, because without that, people lose faith in the system, and then we see that can really breathe a lot of air into far right agendas, for example, and conspiracy theories and other corrosive ways of thinking and doing that will ultimately undermine all liberal economic democracies.
Yeah, totally agree on that one also. And well, as being optimists, of course, we still root and hope for the best. It's, as you said, difficult to predict the future, but in any case, and since I don't see any further questions, we'd like to thank you warmly once more, dear Dean Cunningham, for this excellent presentation, which, again, I have to admit, I enjoyed very much. And so did our fellow participants, for sure. Hopefully, it's not going to take another 10 or 15 years to talk again about that issue. We'd love to meet you again. And therefore, I conclude by wishing you all the very best also to our fellow participants here, and yeah, to express the hope to meet you soon again. So thank you warmly once more.
No, well, thank you so much for the invitation, and congratulations on putting this series together and bringing such a diverse group of people together in the same virtual room. And if any of you have cause to come to Australia, or if you're looking for an excuse to come to Australia, then feel free to be in contact. And likewise, if I'm in Europe, I'll reach out to one or more of you, and it'd be good to connect.
For sure, that would be great. So thank you warmly. Thank you.
Actually, just on that, I am running a program in Ghent in August next year. So I'm planning on being in Belgium for a part of July and a good part of August as well. So perhaps we can find an excuse to catch up at that time.
Would be great. Thank you very much.
Great.
Thank you, and take care then. Thank you. Bye-bye.
Okay. Good night.